This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And this is episode 22. Today we're really getting into constitutional law, specifically focusing on the Seventh Amendment. It's one that sometimes flies under the radar, but it's definitely important.
That's right. We are AI bots, and well, we've been brought to life using AI technology and Angela's really excellent constitutional law notes. Our goal, like always, is to break down these complex legal ideas into something, more manageable for you, helping you tackle the bar exam.
Absolutely. And we really do have to give credit to Angela, the person behind these outlines. She's a law student at George Mason University, and she actually hosts this podcast, sharing her notes with everyone.
Which is incredibly generous.
It really is.
Yeah.
If you have questions or any feedback about the podcast itself, you can shoot her an email at podcast@studyforthebarinyourcar.com.
And for any attorneys listening, if you happen to need help with research or, say, motion writing, Angela also does freelance remote law clerk work. Her contact for that is hello@legalwriterandlawclerk.com.
Okay, so to kind of set the scene for the Seventh Amendment, Angela actually shared a story recently. It's pretty relatable, I think. Her father got one of those jury duty questionnaires.
Oh, yeah. Everyone gets those eventually.
Right. This one was for the Eastern District of Pennsylvania Federal Court. And, it brings up those questions about who actually has to serve.
Mm-hmm. And Angela's notes point out that, some groups can opt out. If you're over 70 or active military or a practicing attorney, you can usually get excused.
But here's the key thing for you listening and prepping for the bar. Law students and recent grads, nope, you can't opt out. You're potentially in that jury pool.
That's right. Although Angela mentioned something interesting from her time as a judicial law clerk. She saw firsthand during jury selection, voir dire.
Yeah, the questioning part.
Exactly. She noticed that attorneys usually tend to try and exclude other legal professionals from the jury.
Huh. That is interesting. So even if you can't opt out as a law grad, you might get filtered out anyway during voir dire.
It often happens, maybe because lawyers think other lawyers or law students might analyze the case differently or focus too much on the legal technicalities rather than just the facts presented. It's a strategic thing.
So you have this right to a jury trial, but then the practical reality of who actually sits on the jury can be quite different. It's a great lead-in to our topic today.
It really is.
So today, we're going to use Angela's outlines to really dig into the Seventh Amendment. It might seem a bit less prominent than some others, maybe, but understanding its details, its nuances, can really make a difference on the bar exam, especially for spotting issues.
That's a really critical point. The Seventh Amendment might not be tested with the same intensity as maybe the Fourth Amendment's search and seizure rules or the big federalism questions under the 10th or even the 14th Amendment's broad scope.
Right. Those seem to come up constantly.
They do.
But
elements of the Seventh Amendment pop up pretty frequently. You might find it woven into a civil procedure essay, maybe, or it could be a subtle point in a multiple-choice question about civil litigation. It's often about recognizing when the right to a civil jury trial is even relevant. Missing that can cost you points.
Okay, so let's get into it. To really understand the Seventh Amendment, we should probably start with the actual text. Can you read it for us?
Sure thing. Here it is, verbatim. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of unbelieved the United States than according to the rules of the common law.
Okay, preserved, suits at common law, re-examined, lots of key phrases there.
Exactly. And when you break it down, like Angela does in her notes, you see two main parts that are super important for the bar. First, it preserves the right to a jury trial, but only in certain kinds of civil cases. That's key. And second, it puts real limits on how federal courts can look again at the factual findings a jury has already made. We need to unpack both of those.
Right, let's start with that first part, and that phrase right at the beginning. In suits at common law. What exactly does that mean for our purposes?
That phrase is, it's fundamental. It immediately tells you this right applies specifically to what we call civil cases at law. And distinguishing that from other types of cases is crucial for civil procedure and definitely for the bar exam.
So, at law, as opposed to what?
As opposed to cases historically decided in courts of equity or admiralty. This goes back, as Angela's outlines explain really well, to the English common law system around 1791 when the Bill of Rights was adopted.
Ah, the historical context.
Precisely. Back then, juries were a really big deal in English common law. They weren't just deciding facts. Sometimes they acted as a check on the government. They might acquit someone even if the facts looked bad, maybe to protect what they saw as fundamental rights or push back against the crown.
Right, I remember reading about cases like William Penn, the Quaker.
Exactly. The jury refused to convict him despite pressure from the judge, or John Lilburn before that. These cases kind of showed why people felt the jury was so important, a sort of shield for the common person against potential government overreach.
So that history explains why they wanted to preserve this right in the Bill of Rights.
Yes, and preserved is the key word there. It doesn't mean creating new rights to jury trials for every modern lawsuit. It means keeping the right as it existed back in 1791. So the crucial question becomes, would this type of case have had a jury trial back then? If yes, the right is preserved. If no, then generally the Seventh Amendment doesn't grant one.
Okay, so that leads back to the distinction you mentioned at common law versus equity and admiralty. Those didn't have juries back then.
Generally, no. Courts of equity handle different kinds of remedies. Think about things like injunctions, court orders telling someone to stop doing something, or specific performance orders forcing someone to follow through on a contract, like selling a unique piece of land. Those are equitable remedies.
Not just money damages.
Right. The classic common law remedy was money damages. If you're suing for money because someone breached a contract or caused an injury, that's usually a suit at common law. If you're asking the court to order specific action, you're probably in equity. And admiralty, well, that deals with maritime issues, ships, sailors, things happening on the water, and that also had its own separate tradition, usually without juries.
Got it. So if the bar exam question involves someone asking for an injunction to stop a neighbor from building a fence, or a case about a shipping contract dispute on the high seas,
then the Seventh Amendment right to a jury trial probably doesn't apply. That distinction between law and equid-admiralty, like Angela stresses in the outlines, is a really common place to get tripped up. You need to spot what kind of relief the plaintiff is seeking.
Okay, that's clear. Now, what about the scope? The amendment says it applies in any court of the United States. What does that limit mean?
It means exactly what it says. This right applies in federal courts, the ones established under Article 3 of the Constitution.
So the federal district courts, courts of appeals, the Supreme Court.
Exactly. Angela's notes touch on this federal judicial power, covers cases dealing with the Constitution, federal laws, treaties, admiralty, disputes between states or between citizens of different states, diversity jurisdiction. The Seventh Amendment operates within that federal system.
Okay, and here comes, I suspect, a really important point for the bar exam.
You suspect correctly. This is huge EE. The Seventh Amendment right to a jury trial in civil cases is not incorporated against the states through the 14th Amendment's Due Process Clause.
Not incorporated. Wow. So unlike, say, freedom of speech or the right against unreasonable searches, this one only applies to the federal government.
That's absolutely right. Most of the Bill of Rights has been applied to the states via the 14th Amendment, but the Seventh Amendment's civil jury trial right is a major exception. States are not required by the U.S. Constitution to provide jury trials in civil cases.
So a state could theoretically abolish civil juries entirely.
Theoretically, yes, without violating the federal constitution. Now, most states do provide for civil jury trials in their own state constitutions or laws, but they aren't compelled to by the Seventh Amendment. This is a classic federalism point and a favorite bar exam trap. Don't assume it applies to state court proceedings.
Definitely noting that down. And quickly, that mention of the value needing to exceed $20.
Yeah, that's just a historical artifact. $20 was, a more significant sum in 1791. For bar purposes, just recognize it's in the text, setting a very low threshold. But it's not really a practical issue today. It just ensures the right doesn't apply to absolutely trivial monetary disputes.
Yeah. Let's move on to the jury itself. The amendment says the right is preserved. What did the jury look like at common law, and how does that compare to today?
Well, traditionally, the common law civil jury had 12 members, and their verdict generally had to be unanimous. That was the model in 1791.
But we know federal civil juries today aren't always 12 people, right? Sometimes they're smaller. How does that work with preserving the right?
That's where things get interesting, and where the Supreme Court had to interpret what preserved really means in a modern context. The key case here, mentioned in Angela's notes, is Colgrove v. Batten from 1974.
What did Colgrove say?
The court held that a federal civil jury with only 6 members is constitutionally permissible. It doesn't violate the Seventh Amendment.
How did they justify that if the tradition was 12?
Their reasoning was essentially that the number 12 wasn't the crucial, indispensable feature of the common law jury trial right that needed to be preserved. What mattered, they said, were the jury's essential functional characteristics.
Functional characteristics, meaning,
Yeah.
like, its purpose.
Yeah, basically. The core function is having a group of impartial laypeople from the community stand between the parties and the judge to decide the facts. The court felt that a 6-person jury could still perform that essential function adequately. It was a more pragmatic reading of preserved, focusing on the substance of the right, not necessarily every single procedural detail from 1791.
So the Constitution allows for some flexibility in the size, as long as the jury's core role as fact finder is maintained.
Exactly. It balances the historical right with, the practical needs of the modern court system. So while 12 might be the historical image, it's not a rigid constitutional requirement for federal civil cases today. 6 is okay.
Okay, that clarifies the size issue. Now let's tackle that second big clause in the amendment, the reexamination clause. Can you read that part again?
Sure. It says, "And no fact tried by a jury shall be otherwise reexamined in any court of the United States than according to the rules of the common law."
No fact shall be otherwise reexamined. That sounds pretty absolute. What's the core idea here?
The core idea is deference to the jury. It puts strong limits on a judge's ability to second-guess or overturn the jury's findings on factual issues. Once the jury decides what happened, based on the evidence, that decision is generally supposed to stand. It really emphasizes the jury's role as the ultimate finder of fact.
So it protects the jury's verdict on the facts.
It does. It's about maintaining that historic and really important line between the judge's job applying the law and the jury's job finding the facts. The clause aims to prevent judges from just substituting their view of the facts for the jury's view.
But there's that crucial exception at the end. Then according to the rules of the common law. What does that mean? Does it mean judges can sometimes re-examine facts?
It means that certain actions by a judge, which might look like re-examining facts, are actually permissible because those actions also had precedent under the common law system that existed in 1791. These are seen as inherent judicial powers necessary for the proper functioning of the trial system, not violations of the jury's role, and understanding these exceptions is critical for the bar.
Okay, let's break those down. Angela's notes mention several. First, a judge could apparently express an opinion on the facts. That sounds like it's crossing the line.
It sounds like it, but there's a crucial condition. A judge can comment on the evidence, maybe summarize it, maybe even offer a tentative view on the facts, but they absolutely must make it crystal clear to the jury that the final decision on the facts rests entirely with them, the jury.
So it's commentary, not direction.
Exactly. The judge can't pressure the jury or imply they must find the facts a certain way. It's supposed to be helpful guidance, maybe clarifying complex evidence, but the ultimate factual determination has to be left unequivocally to the jury. It's a delicate balance.
Okay. What's the next permissible action? Directing a verdict.
Right. Specifically, a judge can direct a verdict for the defendant if the evidence is insufficient. This is sometimes called a judgment as a matter of law, or JMOL.
How is that not re-examining facts? The judge is basically saying the plaintiff loses without the jury deciding.
Because it's framed as a determination of law, not fact. The judge is saying that even if you take all the evidence presented by the plaintiff as true and draw all reasonable inferences in their favor, it's still not legally sufficient to support a verdict for them. No reasonable jury could find for the plaintiff based on that evidence.
So there's no genuine factual dispute for the jury to resolve.
Exactly. The judge isn't weighing conflicting evidence or deciding who's more credible. They're saying, as a matter of law, the plaintiff hasn't met their burden of production. They haven't presented enough evidence to even create a triable issue of fact.
Got it. It's about legal sufficiency. What about setting aside a verdict and ordering a new trial? That definitely sounds like overriding the jury.
It does, but again, it's permissible under certain common law grounds. A judge can order a new trial if, for example, the verdict was truly against the manifest weight of the evidence, meaning it's clearly wrong based on the evidence presented, or, more commonly, if there was some significant error during the trial process itself.
Like what kind of error?
Maybe improper evidence was admitted, or the jury instructions were wrong and prejudicial, or there was juror misconduct. The idea isn't that the judge disagrees with the jury's factual conclusion on the merits, but that the process leading to that verdict was flawed or unfair.
So the judge isn't substituting their factual finding. They're saying the first trial wasn't fair, so we need a do-over.
Precisely. We need a new, fair determination of the facts by a new jury, because the first one was tainted somehow.
Okay, and the last one mentioned is remittitor, requiring the plaintiff to remit damages.
Right, remittitor. This happens when a judge thinks the amount of damages the jury awarded is excessively high, like way beyond what the evidence reasonably supports. Maybe it shocks the conscience.
So the judge can just lower the amount?
Not quite directly. What the judge does is offer the plaintiff a choice. Either accept a lower, reduced amount that the judge deems reasonable, or face a whole new trial, usually just on the issue of damages.
So the plaintiff has to agree to the reduction.
Correct. The judge isn't unilaterally imposing a new damage figure. They're essentially saying the jury's number is legally unsustainable, but offering a way to avoid a new trial if the plaintiff accepts the reduction. It's seen as a control on excessive verdicts, grounded in the judge's role of ensuring the outcome is within legal bounds, rather than a direct refinding of fact about how much harm was suffered.
So all these actions, commenting on facts, directed verdicts, new trials, remittitures, they all seem to be about the judge acting as a sort of gatekeeper.
That's a great way to put it. As Angela's outline suggests, these are gatekeeping functions. They ensure the trial process maintains legal integrity, that outcomes aren't based on insufficient evidence or procedural errors or legally excessive awards, all without fundamentally usurping the jury's core role of deciding disputed facts based on the evidence presented. They are the rules of the common law that allow for judicial oversight while still preserving the essence of the jury trial right.
Okay, that makes the re-examination clause and its exceptions much clearer. There was one last point in the notes about Congress's power to prescribe pleading. How does that connect?
Yeah, that's more about the procedural framework around the trial. Congress sets the rules for federal courts, like the Federal Rules of Civil Procedure. This includes the rules for pleading what you have to put in your initial complaint to even start a lawsuit.
Like the Twombly and Iqbal standards.
Exactly. Those Supreme Court cases, interpreting the rules Congress set, weighs the standard for what plaintiffs need to allege. You need a plausible claim, not just a possible one. So if a plaintiff's complaint doesn't meet that plausibility standard, the judge can dismiss the case right at the beginning.
Before it ever gets near a jury.
Right. So while Congress isn't directly limiting the jury trial right itself, its power over procedure, the rules of the game can absolutely affect how many cases actually make it far enough to have a jury trial. It's an indirect but significant influence on the practical reach of the Seventh Amendment.
That makes sense. It shows how different parts of the system interact. Okay, well, that covers a lot of ground on the Seventh Amendment.
It really does. We went through its core meaning, the suits at common law distinction, the critical non-incorporation issue, jury size, and the really important re-examination clause with its exceptions.
So, wrapping up our deep dive today, we've seen how the Seventh Amendment, while maybe not the most famous, holds some really key principles about civil litigation in federal courts, especially that balance between judge and jury. Understanding these points is definitely valuable for your bar prep.
Absolutely. And again, a huge thank you to Angela. Her constitutional law notes were just fantastic and formed the backbone of our discussion today. Couldn't have done it without them.
Definitely. Okay, just some quick housekeeping and, the important disclaimers we always need to mention for all of you listening while you study.
Go ahead.
First, just a reminder, Angela is a law student, just like many of you. She's not an expert yet, hasn't passed the bar herself.
Second, very important. Neither Angela nor this podcast is giving legal advice. Please don't construe any of this as legal advice. And remember, AI like us, well, we're an aid, hopefully a helpful one, but not a shortcut or substitute for your own hard work studying for the bar.
Third, this podcast should be a supplement to your studies, definitely not your only resource. Use your bar prep materials, practice questions, all of that.
Fourth, AI isn't perfect. Sometimes we might make mistakes. Angela does her best to review and correct things, and her notes are great, but even law students can make errors. We try our best to be accurate, but always double-check if something sounds off.
Fifth, this whole podcast series is an academic, non-commercial project by Angela. It's purely for educational purposes.
And finally, sixth, if you are driving, please be safe. That's the most important thing. Don't cause a tort while listening to us talk about constitutional law.
So I chuckle.
Yeah.
Otherwise, you might find yourself facing a criminal prosecution and needing your Sixth Amendment right to a speedy trial.
Good point. And just a reminder on contacting Angela. For podcast feedback, it's podcast@studyforthebarinyourcar.com.
And for attorneys needing her freelance law clerk services, that's hello@legalwriterandlawclerk.com.
Okay, tradition time.
Tradition time. Gotta have the cheesy joke. All right, ready. Why did the Sixth Amendment break up with the Fifth Amendment?
Uh-oh.
Because it couldn't get a speedy trial from commitment.
Oof. Okay, that's a joke.
Hey, we deliver. Anyway, this is Maude and Claude, your AI hosts, signing off.
We'll see you on the next podcast. We'll be diving into the Eighth Amendment then. Thanks so much for listening. Bye.